Just a reminder that your timer will start off as green and start counting down. When you have 5 minutes remaining, it will turn amber or yellow. When your time has expired, it will turn red and start counting back up. That can be kind of confusing. We ask that when your time has expired that you stop and ask the lead judge, Judge King, if you may continue, and he will direct you as to what to do. Are there any last minute questions for me? It is tight. We appreciate y'all working with us and using the overflow courtroom. And just a reminder, please silence or even better, turn off electronic devices. You may use them at argument table only if it is for the argument at hand. We will get started shortly. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. We want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have three interesting cases, good lawyers, and looks like we're drawing a little bit of a crowd. In the first case, number 24-1355, Walmart Business Trust versus Quarterfield Partners. Mr. Malik, nice to have you with us.
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court. Louis Malik for the appellants, Quarterfield Partners, LLC, et al. This case is about construction of two commercial leases, and we believe the district court committed multiple errors that really flowed from each other. The court ultimately ordered specific performance of a purchase option that's really a conditional purchase option, which turns on a condition that has not yet occurred, and then issued a damages ruling in Walmart's favor that takes no account for the fact that Walmart has occupied these properties rent-free for more than 5 years now and still has not paid for them. So we're asking that this court reverse in every respect.
Does your case depend on us finding that it is a conditional option?
We think that it is a conditional option, yes, Your Honor.
So is that a condition precedent for you to prevail here?
I think we have multiple arguments. I think that the court's errors really flowed from each other, and it starts with finding that it was a true option instead of a conditional option, but we believe the court also erred in its construction of the other terms of this option.
Well, the reason I ask that is since it's a state law question whether or not the option is a conditional option under Maryland law, and I think opposing parties say it's not. Is there any benefit to us having the Supreme Court of Maryland tell us whether or not it is?
Your Honor, in this case, I think that the terms of this particular option are clear enough that that I'm not sure there is, but that is certainly an option if the court decides to do that. But we think that the court can decide this case and should decide this case based on the briefs that we submitted and based on the text of the option itself. Before I address the merits, I would like to say a word about subject matter jurisdiction. The court asked for a supplemental brief, and we submitted one. The plaintiff appellees did not respond. And there may still be an open question here because they've alleged all the record says about their identities and their citizenship is that they're Delaware statutory trusts with principal places of business in Arkansas. And under the Supreme Court's ruling in Americold Realty, that's really not enough for the court to decide the question. The citizenship of a statutory trust depends on the citizenship of its members or its owners, its shareholders. So I'll leave that for the appellees to address, but I'd like to address the merits.
Do you have any position or information about it other than just that it's unknown?
I do not, Your Honor. So our
No
first.
one's made emotions in that regard at all,
That's correct, Your Honor.
either in the district court or here.
That's correct. So our first point of error is that the district court erred in determining that Section 27 of these leases gave Walmart an enforceable and unconditional option. And the leases are really the same in all material respects.
So if you're right, and I'm kind of jumping through because we have read the briefs, and
Yes, Your Honor.
if my question you think it involves some assumption that's contrary to your argument, please let me know. But my question is this: if your position is right, imagine that Quarterfield never submitted a notice and offered to sell the property to Costco. Would that be a violation of the lease?
Your Honor, we think that what Walmart has purchased here is a cloud-on title.
What?
A cloud-on title. And I think that's why that we're here in this litigation, is that Walmart has this right, whatever it might be.
Well, what's the answer to my question? I mean, you said, could they do that without breaching the lease or not?
I think Walmart certainly has equitable rights under the lease that they would assert in an attempt to prevent the sale.
So would they be saying there that Quarterfield violated a good faith obligation under the lease, or? Yeah, I think that's part and parcel of Judge Quattlebaum's
Yes.
question.
It's kind of odd to say they'd have rights. I mean, I'm asking you, would that be a violation of the lease? And I realize it's hypothetical, but it seems like that's a logical extension of your question. You know, either, as Judge Agee says, there's either there's express provision, maybe it's an implied covenant in there. You're talking about equitable stuff. Maybe the answer is that's completely fine. I'm just trying to figure out what's your position, and if you've said it, I haven't really understood it.
Sure, and Your Honor, I think my position is that if Quarterfield did sell to Costco, it would be subject to Walmart's purchase option rights.
So does that mean Walmart has, in your view, a right of first refusal?
It's a conditional option. I think a right of first refusal really depends on there being an offer from someone else that Walmart would then have the opportunity to meet. That's not what we're saying.
So using Judge Quattlebaum's example, Costco offers your clients 2 times X, and they'd like to sell for that. So my question is, in that situation, does Walmart have a right of first refusal?
I think Walmart would have a right to assert its rights with respect to the sale.
You don't like to answer the questions, do you? I don't understand you lawyers.
I mean, it sounds like you're saying, I mean, that Walmart could make some arguments. I mean, everyone can make some arguments. It sounds like I mean, there's nothing wrong with saying that, yeah, we can do that under the lease. Or maybe you say we can't do it. But just saying that Walmart has some arguments doesn't seem, it seems to be saying you think you can do that under the way the lease was drafted. That may be right. I mean, you don't need to back away from it if you think that's your position. But you kind of need to tell us.
Your Honor, I think the answer is yes. Quarterfield could do that. It has not done that. I think this litigation started because there was an issue about a sale. That's not really in the record, but yes, I think Quarterfield could sell to someone else, and Walmart would have the ability to assert the rights that it has as an option holder. Okay. Our position is not that Walmart doesn't have an option, it's that it has an option that's dependent on a condition that hasn't occurred yet.
Wow. And the way, and that means that it hadn't happened yet, and you could, whether it happens depends on Quarterfield sending the notice, and if they don't do it, that option never comes to, the event that, allows them to exercise it never happens, and so they just, that right never comes to pass.
That is correct, Your Honor.
Okay.
Yes. So our position, though, is that the district court really misconstrued this option by reading out the 2 sentences that Walmart drafted, but it's 2 sentences that we think are the most important part of the option, which is
Why doesn't the 3rd sentence suggest that if they don't send a notice, the parties contemplated that the time period for exercising it would move? I mean, the 3rd sentence got kind of gibberish with 9 years in there.
Right.
But putting aside that gibberish, it seems to say, or I think it says something to the fact that if the notice isn't given in year 9, it moves to the year following the 2nd notice or something to that effect.
That's basically correct, Your Honor.
So now, I guess your position is, well, that contemplates us giving the notice. If we don't give it, it doesn't arise. But is a way of reading that, is the better way of reading that not that, okay, the parties contemplated what would happen if they didn't give the notice, and they're talking about moving the period, not eliminating the period?
It does talk about moving, and Quarterfield could decide tomorrow to give notice. I'm not saying they will, but it's
Right.
possible. in which case the option period would move such that it would start after the second notice is given.
So the lease has multiple, if I'm remembering, 5-year renewal options.
Yes, Your Honor.
So just theoretically, in your view of the case, Quarterfield could give, the option term would move, and Quarterfield could give the option in year 50.
Yes, Your Honor.
Okay.
But really, we think this is a conditional option under Maryland law, under the Straley case. And Maryland law does allow for these without them being.
Hopefully none of the lawyers here today wrote this.
I certainly did not, Your Honor. And I don't believe any of the lawyers sitting here before you did. My firm has only been counsel since this present appeal.
That would be a good question not to answer.
But under the Straley case, there are multiple kinds of options under Maryland law. And the courts have upheld options that are conditional, and even rights of first refusal, which are entirely dependent on landowners' desire to sell.
Rights of first refusal at least give a question. It seems like your position needs to grapple with is this. I mean, I understand that reading, but there's Maryland law that frowns on promises that are illusory. And it seems like your position is this is totally up to you, that unlike a right of first refusal, which gives the recipient of that right superior to the rest of the world, this gives Walmart no rights compared to the rest of the world. And why is it not illusory and problematic on that basis?
I think Walmart does have rights superior to the rest of the world.
Why?
Because
We just asked you about Costco, and apparently not to Costco.
Your Honor, I think the way it would work would be if Quarterfield did sell to Costco, Walmart would have the right to come in and say, wait a minute, we have this purchase option. Costco takes.
But you think they'd lose. You just said you think they'd lose. The right gives you to do that. I mean, I think it sounds like your position is this particular provision really doesn't give Walmart anything.
It gives them the right to say that we have an option on this property.
It gives them the right, you're saying their only right is to file a lawsuit.
Well, that's what they did here, Your Honor. That's why we're here.
I know, but you think it's a suit that would lose. So if you think it's a suit that would lose, I mean, sure, you can file a lawsuit, but, my law clerk who worked on this could file a lawsuit about it. I mean, it just, why don't you just say that like you said? It seems like we're going down the same road before, that you don't want to admit it, that this, I mean, it would seem to me you'd say, well, maybe that is, in a narrow sense, some right that's completely within the purview or the control of Quarterfield, but it's part of a multi-page contract with lots of provisions that aren't illusory, and it's part of the baked-in bargain. But you keep seeming not to want to accept the logical extension of your argument.
Yeah, well, Your Honor, I guess that is the logical extension. And this is a very long lease drafted by very sophisticated parties here. And this is the language that they came up with, which I think is the language that the parties are stuck with. And under Maryland law, I think it's the language that the court also was bound by. And ignoring the provision that the option period would move, and assuming that it really happened without notices being given, we think the court drafted a new contract for the parties, which is.
So what would happen, just theoretically, 10 years from now, lease has gone on, and Quarterfield comes to Walmart and says, we're not inclined to give the option. We like the money we're making under the lease. However, if you were to give us 3X, we'll go ahead and sell it to you and send you a separate notice that doesn't go by the purchase terms of the agreement. What happens then?
I think that would be a new agreement with Walmart, and Walmart could say we agree or we don't.
Okay.
So the lease sets a formula for setting what the purchase price will be.
But you would, in your view, that wouldn't breach the lease. That would be perfectly within Quarterfield's rights, correct?
I think any party can ask for a modification of an agreement.
But that's not asking for a modification, as I understand it. That's saying it's a new agreement, but it's not, maybe it's a modification, but that doesn't constitute a breach, in your view.
No, I don't believe so, Your Honor.
Is, never mind, I think I understand. You can
Thank you.
finish up, sorry.
So on the third point of error, which is about the timing of this and when the notice period was, the court deemed it to occur, we think that the much better reading is that the 11th year of this lease means the 11th year of the initial term. That's the fair reading of the provision, and the initial term begins on the effective date, not on the rent commencement date. The court should have applied that reading instead of the extrinsic evidence that really, under Maryland law, was not admissible in the first place. I think with that, I'll reserve for rebuttal. Thank you, Your Honors.
Thank you very much, sir. Mr. Ray?
Good morning, Your Honors, and may it please the court. I think it's important for me to answer Judge Aggie's question first. I did not draft the language of this lease.
That might be one you'd want to lie about even if you did.
No comment, Your Honor. This, in some ways, is a very straightforward purchase options. In some ways, it is ambiguous. As to the purchase option itself, the district court held that the language is clear and unambiguous. From the end of the 10th year of this lease until the end of the 11th year of this lease, lessor hereby grants to lessee an option to purchase the premises on the terms and conditions set forth. The sentence that my opposing counsel
I know the
relies.
district court did that, and maybe that's the right answer. But then you have the second sentence, notwithstanding the foregoing, the option term shall not commence until the lessor sends 2 30-day notices.
Correct.
And it seems under that interpretation, that writes that sentence out of the lease.
I don't think it does, Your Honor. I think it modifies the option term, but not the grant of the option. This is not a right of first refusal. And the cases on which my opposing counsel has relied, particularly the Straley case, is limited to a right of first refusal. And it's interesting that in the case below, in the trial below, Quarterfield argued in one instance that it was a right of first refusal and then withdrew that argument and are attempting to revisit it through this concept of conditional options.
But why isn't, I mean, you know, this is a hard, you know, to me this is pretty hard because of the way it's drafted, but, you know, Judge Agee, I think, makes a good point. Sure, the first sentence says what it says, and if that was the end of it, this would be easy, but it's got the second sentence.
It does.
That says, notwithstanding the foregoing, the option doesn't begin until the second notice is given. That hasn't happened.
That's correct.
So
And-
why are we here? It's, the lease is still going, you hadn't got a second notion or a second notice? I mean, as I understand it, the lease term has got a couple more years on it.
Yes.
Why are we here?
Well, the lease term doesn't, actually. They've passed their 10-year. They're in one of the lease option periods, but the lease is still in effect. I think we're here if you read that provision in its entirety with the entire option language. The next sentence, in fact, reads, in the event lessor fails to send such notice.
And keep going, what's
Yeah.
it say?
In the event that the lessor fails to send such notice at the end of the 9th year, I recognize that's wrong, of this lease, then the option term shall be moved such that it is for a 1-year period commencing 30 days after the second option notice has been received.
And opposing counsel says, yeah, that would apply, and it could apply in year 50.
Yes, and I disagree. I think that the fundamental question for the court is the notice provision, the 2 sentences, an obligation or a discretionary right? If this court deems that it is in fact an obligation, which is what the district court deemed below, based on the fact that it says they shall send notice and has consequences for a failure to send notice. If it is deemed an obligation, then you also have to read the next sentence, which is lessee, Walmart.
Where does it say they shall send, put an obligation that they shall send notice?
Yeah, I'm sorry, Your Honor. It says the option term shall not commence until lessor sends
Yeah,
notice.
that's like the
different.
opposite of what you said. Maybe one could argue that's the opposite of what you said, that there
One
is
could.
no obligation until you until the notice is sent.
One could argue that if you don't look at the language in the event lessor fails to send
Yeah,
notice,
and I think
you have
that
to read
helps
those
you.
together.
I think that helps you.
It
'cause
does. I'm sorry, Your Honor.
But it comes with some uncertainty and maybe some language that doesn't. To me, the fact that it talks about moving, as far as that goes, helps. But it still only says moving, into the year until that second notice has been received.
It does,
So-
Your
and-
Honor.
And there's nowhere that says they have to send it.
I think that there isn't. You're correct. And I think that you need to read it in context as well with the architecture of the entire paragraph and the ultimate outcome. If they don't send the notice, you are negating the option altogether. Why would the parties enter into a right of first refusal and have a very detailed formula for setting the price for the property
Yeah.
and attaching a 30-some page purchase agreement that shall be used and setting a feasibility period of 90 days and a closing date of 120 days, if all the landlord had to do is say, we're not going to send you the notice, you never get to buy the property. All of that gets negated. And in answer to, I think it was your question, Judge Aggie, if they could turn around and sell it to another party for 2X, then they're basically negating all of Walmart's rights to purchase it at 1X.
Well, Walmart has lots of rights under the lease. It's got a right to occupy it. It's got a set rent term.
Does.
I mean, Walmart's hardly a, little old lady in the negotiating sense.
They are not.
They have a lot of leverage in how they, in agreements they reach. And if they entered into agreement that didn't require Quarterfield to send them the notice, why shouldn't we say you're a big boy and know how to make things clear, but didn't, and just go by the fact that there's no obligation that's expressly provided?
Because I believe that Maryland law says you cannot, because of the very question that you raised with opposing
The
counsel.
illusory point?
It renders the entire paragraph illusory.
But is that how it works? I think that's the interesting argument, but does, and I think if we were talking about a standalone agreement that was rendered illusory, that would be real strong. But in the context of a, multi-obligation, multi-provision lease, I mean, does the illusory concept really say each and every obligation in that? Can a party decide that the overall benefits of this lease are such that I'll have something that really doesn't give me much of anything in that one paragraph?
I don't think that Maryland law has specifically and expressly determined whether an entire agreement would be illusory or a particular promise. But Maryland law does say a promise. If a promise is made, which I think would imply each individual provision cannot be illusory. And the purpose also supports that, because the purpose of not finding or not interpreting in a contract in an illusory manner is to give effect to the promises made, all of the promises made. So Maryland law favors a reasonable interpretation that does not result in the provision, the promise, being unenforceable or a forfeiture. And I think that focuses on the language being addressed. And in each of the cases that I have read and cited here, it was focusing on particular provisions within the contract. However, I do agree, Your Honor, I don't recall seeing a case where the distinction between an individual promise and a very complex lease and the whole agreement was addressed by Maryland law.
So do we need to find that as a matter of Maryland law for you to prevail that a single provision of a multi-term agreement in and of itself can be sufficient to be deemed illusory without finding the whole? I guess what I'm getting at is if that's necessary for you to prevail, it raises the question of whether we should ask the Maryland Supreme Court to tell us what the law is.
And I think if that were the only basis on which this court could uphold the district court's ruling below, I might agree. But I don't think it is the only basis. I think there are a number of contractual canons of Maryland law that are very well established on which this court can affirm. One is reading the provision in the context of the overall paragraph, as I've mentioned, with the other provisions in the paragraph. Two is reading it in a reasonable and common sense manner. Three, there is no such thing as a conditional option under Maryland law. There is a right of first refusal. The concept of conditional option applied in the Straley case was singularly applied to a right of first refusal. It has never, in the 55 years since that decision, been expanded to any other form of quote-unquote conditional option. What I believe the appellant has done here is taken language uniquely supplied and applied to a right of first refusal.
I don't mean to cut you
Not-
off.
not
I
at
think I
all.
understand where you're going. So, I mean, it seems to me that would substantially limit the rights of parties to form an agreement. It would, I mean, if the only thing Maryland law would allow was a right of first refusal, what if this said, that had the first sentence just as it is and said, notwithstanding the foregoing, this option shall not apply unless Quarterfield has, achieved a net profit of X percent over the first 10 years of the lease. That's not a right of first refusal. That would be a conditional option, and there would be nothing, I mean,
It very well may
what
be,
we
Your Honor.
call it seems to me not as important as looking at the terms and seeing what they say. I mean, you see what I'm saying? I mean,
fair point.
I know you consider that different than we have here, but it would be maybe a conditional option and given life to that case that you say doesn't apply.
I think that's a fair point, Your Honor, and it might limit, I think that's not our case, obviously.
Right, yeah.
But in your hypothetical, I think it might limit a party's right of contracting with conditions.
Can I move to another issue about
Certainly.
whether the right is mandatory? It seems to me if we agree with you that there is some obligation to send the notice, the third sentence of section 27 talks about if the notice isn't given by the 9th year, then the year period commences at the time the notice is given, whenever it's given. I know that's not exactly right, but I think
Yeah,
that's the way
I
it
understand the
works.
sentence you're referring to, Your
Yeah.
Honor.
Well, I don't understand how that language, given that language, how you can say they already or the district, I don't understand the district court's reasoning that the time for giving the notice has taken place.
Yeah, I think that the time that the notice has taken place was a separate analysis of what does the 11th year of the lease mean, without regard to that provision. However,
But clear, well, I want to let you answer, but it seems like if you want to rely on sentence 3 to say, hey, there's a real option here, you can't run away from it. It doesn't, I mean, almost by definition, it's talking about some period other than the end of the 11th year. Why doesn't that apply to the whole lease term?
that's correct. Let me start the answer here. I agree with you, and I think the conclusion that you're coming to is, doesn't sentence 3 limit or condition the option period, such that it may not be in the 11th year, it may be at a later time? And I would say that, standing on its own, would. However, you also have to read the next sentence, which says the lessee may exercise the option. Now, let me read the whole sentence.
Yeah, yeah.
So the lessee may exercise the option to purchase the premises by providing 30 days' notice to lessor of its election to exercise the option, herein defined as the option notice. If you read that sentence as conditioned upon the prior sentence, that they can't do that until option notices are sent, then we're back to the original argument, which is they can negate the entire option by simply not sending the notice.
Yeah, I'm not following the connection
Okay.
there. I mean, there's next sentence, I guess fourth sentence, is talking about how you exercise the option.
Right.
I don't understand how that sentence relates to the question of when the option must be given.
Let me try and
The
explain.
district court said you got to do it by the end of the 11th year, I think. And I'm like, I'm trying to see how that seems like that's writing in a term to the lease that's not there.
Well, I'm not sure I agree with that, Your Honor. I think the district court said two things. It said, one, yes, the judge identified the 11th year from the rent commencement date and defined when the 11th year is.
Right.
Under her understanding of an ambiguous term and extrinsic evidence. But then also interpreted when Walmart could send its own notice. Now, we've got to read those two provisions harmoniously. If, based on your question, that we may only send the notice, our exercise of the option, once we receive notice, then the 11th year is meaningless, because the option period only begins when the landlord sends notice. So who cares when the 11th year is? It is a superfluous clause. The only way that you can read that clause as having meaning is that the option term is in the 11th year, and one of two things triggers the option. Either the landlord is required to send notice, two notices, which triggers that option before the 11th year begins. But if the landlord doesn't, and this is our case, then Walmart has the right to exercise its option during the 11th year or thereafter. And I think that was the holding of the district court,
Yeah, I
trying to
don't
harmonize
disagree,
this.
but, yeah, I hear it.
All right.
Thank-
So I think fundamentally, Your Honors, that the question here is whether that notwithstanding language and the notice provision is an obligation or a discretionary right. I would like to note one point, because you were talking about this is a broad lease, lots of clauses in here, and we cited many of those clauses in our brief, and I would just like to bring them to your attention, because when the parties wanted to recognize a discretionary right, they used those words, and these are sophisticated parties, and they used the words, tenant shall have the right to send notice, landlord shall have the right to do something. It is within landlord's sole discretion to do something.
Yeah, but that cuts both ways, right? I mean, yeah, you have, it could have said, I mean, it could have been more clear in your favor too.
It could have been.
Yeah.
But also, when you look at that in context, when the lease has talked about failures to do something, it has implied obligations.
Can I switch to one more question?
Of course you can.
related
As
to
many,
damages?
I'm here to answer
Yeah.
your questions.
There's this issue about damages.
Yes.
And, yeah, and I know we got some standard review issues and things like that, but if a court were to order specific performance, let's assume you win on everything and you get specific performance, wouldn't the way you deal with damages to really would be, yeah, that, I mean, if you're going to get prejudgment interest on rent that you paid, doesn't the kind of underlying principle of that indicate you would have or should have been able to and had paid the purchase price? So that same period that you paid rent, under your theory, you would have paid the purchase price. You wanted to pay the purchase price.
Correct.
To Quarterfield, right?
Are you saying as a hypothetical on the, because we're not claiming prejudgment interest?
I
on
thought
the
you were
rent.
claiming
We
prejudgment.
dropped that claim.
Have you?
Yeah,
Okay.
yeah,
I
yeah.
got you. I'm sorry.
Yes, I'm sorry. No, that's all right, but I think what the underlying issue that you may be alluding to is putting the parties in the position they would have been
Would they
without the
be-
breach.
And would they, if you're dropping your prejudgment interest claim, I didn't pick that up, I'm sorry.
That's all right.
But I'm trying, okay, let me, that covers that point.
Okay.
Let me bring you back to what we started with opposing counsel a little bit. The Walmart Real Estate Business Trust, and it's a Sam's Business Trust as well. Have you filed anything that tells us who those beneficiaries are for diversity purposes?
We have not, Your Honor, and it was not, as Judge King noted, it has not been challenged or raised. Well, it is
Well,
a Delaware
but
business
it goes-
trust.
It goes to subject matter jurisdiction, doesn't it? And we have an obligation to make sure we have it, so looks like you ought to file a 28J letter or something so that we're assured of jurisdiction in this case.
You still claiming we have jurisdiction?
I do, but you're right, and I will.
Okay?
So, thank you for bringing up the process. That will be the rest of my day. I see my time is up. If there are no other questions, I'll conclude there and just simply say that I believe that the district court should be affirmed in all respects. Thank you, Your Honors.
Thank you.
Thank you, Your Honors. I think the point of this lease here is that it's a very long document. I think it's 43 pages, single-spaced and small type. It conveys a whole bundle of rights, separate and apart from this purchase option. These are sophisticated parties, and this language, unfortunately, is what was agreed to. But I think the point is that this is what Walmart wanted, as well as what Quarterfield wanted. The parties agreed to it. They agreed to this language, and they ought to be held to it. And even on the point of whether or not this particular part is illusory, the contract spells out what the parties have agreed to in terms of a framework for how this purchase option is exercised, what the price will be, and how the transaction goes forward.
What do you think the Maryland law is on an illusory contract? Does it require the entire contract to be illusory or simply a provision? And does it have to be a key provision that's illusory?
Your Honor, I can't cite you to a case on that off the top of my head, but I think logically it should be really the key provision to negate a part of a contract, or really, I think a large part of the contract. Walmart would say it's got to be, I think there's a materiality aspect here. And
Well,
this
is
is,
this part material? I mean, that's why we're here. Must be material.
Your Honor, it's one paragraph of a very large lease. And the lease conveys all these other rights that I don't think anybody else is contending are illusory. I'd be happy to submit further briefing on that if the court would like, but I don't think that we're in the position here of having the whole contract struck down for this being illusory, and I don't think it is illusory to begin with because of the rights that are conveyed. This is not an empty gesture. There are rights conveyed here in terms of what would happen if Quarterfield did give notice. And really, I think when it comes
Well,
to...
if we assume, just for argument, that we affirm the district court's order in so much as it says that the option was required to be given and is deemed to be given. You made an argument, I think, that there should be some sort of an offset. You want to give us 30 seconds on that?
Absolutely, Your Honor. And that's, when we're talking about specific performance, we're talking about equity. And equity is about fairness in a lot of ways. And the damages award here is really the hallmark of why this case, why the decisions were unfair to Quarterfield. It takes no account for the fact that Quarterfield has had these properties, they've occupied them rent-free, and while still holding on to the purchase prices for more than 5 years now. if Walmart had paid this money 5 years ago, their argument might hold more water, but they haven't. They've retained the benefit of millions of dollars. The total purchase prices for both these properties is, I think it's $16.8 million.
So are you claiming you should have the time value of that money? Is that?
Yes, Your Honor.
Do you have how would, I'm just trying to think how that, procedurally would work. I mean, have you made like a counterclaim, an alternative counterclaim, or are you just saying, because I heard that being like a defense to their claim for prejudgment interest, but they say that's gone. So now you're saying, and I get the economic reason you're saying that does kind of follow, but procedurally, have you, I don't mean to beat anyone up about how you litigated the case, but I would think you would make a claim for that. That would be a, actual claim for relief rather than just coming here and saying due equity.
Right, and there was not a counterclaim made, and that was not done below. And it did come up in the context of Walmart's request for prejudgment interest, which was denied, and they cross-appealed and then dismissed their cross-appeal. But I think it's emblematic of the way these decisions worked in Walmart's favor.
You would say that's just inherent as part of a specific performance type of equitable award?
I think so, Your Honor. It shows how unfair this was, and really specific performance is reserved for contracts that are absolutely clear. And this one, we say it's unambiguous, but it might be unclear in certain respects. And so I think it's part of decisions that were kind of flowed from each other and created more errors as they went along to create a summary judgment. So for those reasons, we ask that the court reverse. Thank you very much.
Thank you very much, sir. Appreciate counsel's arguments. We'll come down and greet counsel, and then I'm going to exercise my discretion and take a brief break.
The Honorable Court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
You may be seated. In our second case this morning, number 24-1493, we have Bestwall versus the Official Committee of Asbestos Claimants. Mr. Frederick? Good to have you with us, Mr. Frederick.
Thank you, Judge King, and may it please the court, David Frederick for the official committee. I'd like to reserve time for rebuttal. The Constitution's bankruptcy clause has never encompassed debtors who are able to pay their debts to creditors. Yet as the bankruptcy court found and Bestwall concedes, Bestwall has, quote, the full ability to meet all its obligations.
What's your best case since the founding that supports that premise?
Well, Wright defined what a proper subject of bankruptcy is in terms of who the debtor is. Wright relied on Justice Blatchford's definition from In re Riemann. Justice Story, in his commentaries on the Constitution, had the same definition, and there is no case involving a debtor who was fully able to pay all its debts. I want to point to the concession and the finding by the bankruptcy court in the constitutional matter.
Are you saying that there's, because I had a little trouble figuring out exactly what the argument was. Are you saying there's a subject matter jurisdiction defect here under the bankruptcy clause?
Yes. Let me
All right.
explain.
So tell us what case we've had since 1788 that says that.
Well, what the courts have said, the Supreme Court has said in several cases, including the Railway Laborers Executive case and in the Wright case from the 1930s, that the subject of bankruptcies is not unlimited. And the reason why this invokes the subject matter jurisdiction of the federal courts is that Article 3 makes clear that federal courts are courts of limited jurisdiction. So if the bankruptcy clause is read to allow any person claiming to be a debtor, that transforms the state law claims that otherwise a federal court would not have jurisdiction over into federal bankruptcy claims. And that delimitation, Judge Agee, implicates the subject matter jurisdiction of an Article 3 court.
How could you be a Chapter 13 debtor?
I'm not sure I follow.
Well, because there's no requirement in the statute that fits what you say. I mean, if your theory is correct, it seems like to me there are thousands and thousands and thousands of Chapter 13 cases or Chapter 10 cases or Chapter 11s that are simply void.
Well, no, Your Honor, because any bankruptcy has to involve some level of non-payment by a putative debtor. And that is a foundational North Star component to
Didn't
what
Johns Manville, didn't in the case where we have the first 524G concept, if not statutory provision, then, involve a debtor who was able to pay its debts as they were and was worried about the implications of future liabilities?
The way Johns Manville has been described and understood is that at some point in a foreseeable future, Johns Manville would be unable to pay. And I would note, this is outside the record, but the Johns Manville Trust is only paying 1% of the trust amounts to putative claimants. So as a matter of both fact and how it was understood at the time, there's no question that Johns Manville was in distress and was unable to pay in a meaningful understanding of bankruptcy. Now,
Can I just, I'm trying to in thinking about this, it seems to me it's, that there's a question that I understand that the committee making about the financial distress requirement. And the question I have, though, is whether that's a subject matter jurisdiction requirement. It seems, I wonder why this isn't fairly simple. The Constitution gives federal courts, you're right, they're limited, but the way they're limited is by, to disputes involving matters involving the laws of the United States, or I'm not getting it exactly right. The Bankruptcy Code is a law of the United States. it seems, why isn't it not subject matter jurisdiction-wise that simple? And your argument, however good it may be, and I'm not discounting it at all, is an issue that comes up, maybe, it's already come up once in the bad faith context. It could come up later in the confirmation context. It could come up in the eligibility, maybe very, very legitimate argument, but it's not a subject matter jurisdiction argument.
It is, and here's why. Subject matter jurisdiction goes to the power of the courts. The bankruptcy court recognized that this was a subject matter jurisdiction question because it went to the bankruptcy court's power. If you were to accept the other side's argument, it would be a delimitation on structural limitations on federal court jurisdiction, and here's why. It federalizes state law claims that the claimants would be bringing against the debtor, the wrongdoer, the tortfeasor. These are all state law tort claims. And if you accepted the idea that a non-paying or a fully paying debtor gets to bypass the state court process by going to federal court, you are taking what would have been a limitation on the federal court's jurisdiction over state law claims
But the
and
debtor
transforming it into a subject matter jurisdiction point.
But the debtor, I think I'm having trouble connecting that. Because I take it that there are a bunch of state law claimants. These cases tend to, not exclusively arise in state court. They could be in federal court with diversity, jurisdiction. But generally, they're state court cases. I grant you that. But a debtor could have all sorts of state law claims. It could have state law contract claims. Someone could be suing a debtor for not paying a lease. We just got through with a lease case. And that all gets wrapped up in bankruptcy, and we don't have a problem there with jurisdiction.
Because the limitation of the bankruptcy clause has to go to non-paying debtors. If it's a fully paying debtor, there's no reason for it to be in bankruptcy, and there's no reason for the Constitution.
Which is a great policy argument for the Congress, but I go back, tell us again, what do you think is your absolute best case that says this? Because I'm just not seeing anything since 1788 that adopts your position.
And the reason, Your Honor, is because you can't find anything from 1789 for a debtor that agrees to fully pay all of its liabilities now and, quote, in the foreseeable future. That's at JA 1906.
So for 230 years, this has never come up.
That's correct.
This is
a total.
We're plowing a new furrow. Is that right?
That is absolutely
That's
right. And I
that's where we
acknowledge,
are.
I candidly acknowledge, Your Honors, this is a
this is-
novel argument. It is a novel argument because for 4 years and 3 months, the district court would not rule on whether the statutory problem that we identified in the first motion to dismiss should be the subject to appellate review.
And
The
which
original,
term are you using to decide whether they can't get into, or whether they can get into bankruptcy court? You're not arguing insolvency.
no,
Financial distress?
no, non-payment. We think that the test.
Non-payment.
Non-payment.
And that's what,
And-
that's what
and-
Justice Story said?
That's correct. What Justice
What
Story.
was that, 1840 or something?
That's correct, and it was in the commentaries on the Constitution, and
So the Third
It was
Circuit's
not in a
wrong.
case. It was
No, but
not in
the-
a case. Justice Story wrote some books, didn't he?
I understand, and 100 years later in the Wright case in the Supreme Court said, the purpose of bankruptcy is to relieve the honest debtor of oppressive indebtedness and permitting him to start afresh. The Continental Illinois case from the Supreme Court said the subject of bankruptcies concerns a failing debtor's obligations. And even in Carolyn, this court said that if the debtor is not worthy of protection and rehabilitation, then bankruptcy has lost its reason to exist.
Sure, and I don't say sure by agreeing or disagreeing, but that might be a great argument. Might be a winner on whether you're eligible debtor. It might be a winner, probably wasn't this time on bad faith, but it might be a winner, particularly if you have a plan that later on the road doesn't implement Section 157 or implies a payment scheme where people are going to get the Johns Manville sort of haircut when there's no basis for it. But still, there's a separate question of whether that's jurisdictional,
And the
and I just
reason-
don't
yeah,
understand that.
So Congress cannot enact laws that violate the due process rights or the jury trial rights of claimants. The justification for bankruptcy allowing it the power to do so is because there is a limited amount of money to distribute.
So the Fifth and Seventh Amendment are a hook for you.
Correct. And that's because if Congress is deemed to be having the power to do anything in bankruptcy, the previous case that we just heard could have come to you through bankruptcy because of a desire from a fully able-to-pay debtor simply choosing to go to the bankruptcy route and forcing the creditors to go through that process in order to resolve the lease dispute that they apparently had.
So under your view, when a creditor asks for relief from the stay in order to pursue an existing case, they're making a Fifth and/or, if it's a jury case, Seventh Amendment claim.
It could be, Your Honor, and I don't want to re-argue the last case that was before you in this cycle. It
Well,
really,
it might be helpful for us to resolve the last case, actually.
well, what I would say is here, I don't have a brief to re-argue that. We accept the idea that you concluded that it was related to, for purposes of that, injunction jurisdiction. But what I am saying is that the debtor can't bring a bankruptcy to begin with under the meaning of the Constitution if it's willing to pay everything. And JA's
You're saying
1906.
Bestwall is willing to pay everything,
Correct.
and they got a funding agreement, or is that what it's called?
Yes.
Some kind of a deal with new Georgia Pacific.
GP, right.
That whatever they pay in connection with these asbestos cases, asbestos claim, is going to be repaid.
That's
Defense
correct.
costs, damages, whatever comes up, Bestwall's saved harmless.
Correct.
Is that what would be a save harmless agreement? I don't know what it is.
Well, I don't know exactly whether you would call it a hold harmless
Hold
agreement or not, Judge.
Indemnification.
It's an indemnification for sure, and the point is that this is a $30 billion company
So
that is
as a result of that,
guaranteeing.
Bestwall's not, it doesn't have any business being in the bankruptcy court.
Correct. It doesn't have any business to
And that's what the-
rehabilitate.
That's what you got certified here to us. Now, the question on whether it was subject matter jurisdiction, the bankruptcy court ruled in your favor.
Correct.
It said that went to subject matter jurisdiction.
Right. And in answer to Judge Quattlebaum, I'm trying to give you the structural reasons why it has to be viewed that way, because otherwise bankruptcy becomes the fish that swallows the ocean of limitations on federal court jurisdiction.
So tell me how a Chapter 13 proceeds under your theory. Because there's zero in the statute that says what you say.
Your Honor, I am not familiar with Chapter 13 processes, and if you want to ask me an example based on your knowledge that I can, try to answer, I can try to do so. What I would,
Well, but none of the, that's, I guess my point is that there's a very specific statutory requirement that an individual has to fulfill in order to file a 13. Now, when you get into it, you may find out, well, they're ineligible because they don't meet those requirements. But there's no requirement in there that they, depending on the phrase you want to use, they can't pay their debts, they're actually bankrupt, they're insolvent. None of that appears. And Congress knows how to do that because it wrote it into the Chapter 9 provision, a specific insolvency requirement. And I think that's the only place it shows up in the entire code.
but my point, Your Honor, is that this is a Chapter 11 reorganization, and the reorganization for a
Right.
debtor
Both
has to.
11s and 13s were unknown at the time the bankruptcy clause was adopted. And it just, I don't mean to keep coming back to this, but it seems like under your argument, it would void basically all Chapter 13 cases.
I'm not here to argue about Chapter 13, but what I am here to argue about, Judge Agee, is that Congress does not have the power to delimit federal court jurisdiction. We know that there are protections for jury trial rights, for opt-outs under due process. I want to point you to the Ortiz v. Fiberboard case, which says that when you impose mandatory aggregate limits with no opt-out rights, that is a violation of the due process rights of the claimants. And Congress can't override that. That's a constitutional ruling in principle. And so, however the machinations of different titles of the bankruptcy code might work, we know Chapter 11 cannot operate in the way Bestwall is seeking to do, because that application runs afoul of the bankruptcy clause.
Can I ask one follow-up, and I know you're out of time, but if our lead judge is okay with this question, I'd like to get your view on it. It sounds like your position, there's a lot of hullabaloo about Texas two-step and things like that. It sounds like your position here today doesn't have anything to do with that. That whether or not you're a one-step, two-step, three-step, four-step, the debtor, it's got to be unable to pay their debt.
That's correct.
Okay.
That's correct. And we're not here to re-argue state law with respect to, we are here to challenge the second step, which is the declaration of bankruptcy.
I got another question too, on some facts. Our recollection from the earlier case was the number came up of potential asbestos claims pending was around 30 or 40,000. And in your papers, I think you refer to the number 56,000. Do we know, do we really know, or are we talking about potential claims and aggregating them or not aggregating them? What are we talking about here?
Well, we are talking about future claimants as well, whose asbestosis has not materialized.
Those are estimates, those numbers?
I beg your
Is
pardon?
56,000 the best number?
I think that is
You
as
got
good
that
as
in your
I can.
brief somewhere.
That's as good as I can do for you standing here today. But I would say that 25,000 of those have died since the bankruptcy was filed 8 years ago, and that there's no prospect that this bankruptcy is going to end. The estimation trial is not going to occur until November 2027, and it may take 2 or 3 years after that for any kind of confirmation. And where Bestwall is seeking to have a cap on its aggregate liabilities, the whole reason why we're here is because they were paying claims, Georgia Pacific was paying claims in the state tort process, and decided to shunt all of these disfavored creditors into a process by which they could cap their liability.
But how they cap it may be a valid issue. We don't know how they're capping, right? That's a confirmation issue.
That's
right?
correct, but what I'm saying is that principle gives rise to the due process problem that Congress cannot override by saying, we're going to strike the bargain. Here's the bargain. The constitutional bargain was, we're going to give non-paying debtors who are either unwilling or unable to pay a fresh start. But it was all predicated on non-payment of their debt. And what the Bestwall bankruptcy is seeking to do here is to violate that core North Star constitutional principle that justifies why we have bankruptcy in the first place.
Now, of that group of cases, whatever the number is, do you know what percentage of them are in the state courts and what's in the federal court?
They've all been stopped. They were all brought.
I know, but they're everywhere, though.
They're everywhere. They were
Every
stayed.
state in the union,
Yes.
in most every court.
I would presume that's correct, Judge King, because that's
Nobody's done an
typically,
inventory to figure it out.
they were all stopped, though,
All right.
by virtue of the automatic stay. And it's that idea, Your Honors, that what Bestwall is seeking to do is to transform disfavored creditors while using new GP to take care of the creditors that it wants to, that creates the constitutional problem that no courts have had to grapple with because no debtor has had the audacity to do what Bestwall is doing in this case. I'm happy to answer more questions. I think this is a very difficult and challenging case, and I'm here to help the court as best I can.
You've reserved some time.
Thank you.
Mr. Francisco? Nice to see you, sir.
Thank you, Judge King, and may it please the court, Noel Francisco for Bestwall. At the time we filed this petition, there were 64,000 claims pending in the tort system, half of them for 10 years or more languishing, 3/4 of them for 15 years or more. At the same time, we were spending about $40 million a year just in litigation costs. This obviously benefited no one. Our proposed plan, in contrast, seeks to pay every valid claim 100 cents on the dollar and fast, and significantly, it only applies if a supermajority of my friends' clients actually support it.
So
That-
I'm sorry on that, is the plan been proposed?
Your Honor, there's right now kind of a placeholder plan while we try to negotiate agreement with my friends. You really need to have the estimation process done before people can, before their clients, frankly, can make a reasonable decision on whether or not they want to vote in support of it. Up until now, we've been bogged down primarily because we faced a lot of resistance from our friends on the other side, including the appeal you had here in the contempt case, an appeal we had to take in the Third Circuit, where they're really fighting the estimation process. Our very strong interest
And these
is to get this thing
claimants are
done.
dying. These claimants are dying fast. He said 25,000 have died.
And Your Honor, when they were in the tort system, they were languishing in the tort system for 10 years, 15 years, or more.
Well, some of them were getting trials.
A very small number of them were getting trials. Our plan, in contrast, is the only possible way that you can possibly pay both the current claimants and the future claimants fast and in full without exposing everybody to the uncertainty that's inherent in the asbestos process. That's exactly what 524G is aimed at getting at. It's aimed at eliminating the uncertainty that's inherent in asbestos litigation. Asbestos disease has a 50 to 60-year latency period. Nobody knows what the world is going to look like in 50 to 60 years. The whole point of 524G is it allows us to eliminate that uncertainty today, not just for our benefit, but for their benefit and the benefit of all of the future people who aren't going to even manifest the disease for 50 to 60 years.
All that's it is very helpful. And it sort of relates to the prior cases, may relate to a case that comes up on plan confirmation or some other point. But as I understand your opponent's argument, what we're here on now is solely their claim of subject matter jurisdiction defects. So whenever you're ready to move to
That is plainly wrong, Your Honor. The basic argument that they're making is that applying Chapter 11 to this case violates the bankruptcy clause. That's no different than coming in and arguing the application of a statute to a particular case violates the Commerce Clause. Nobody thinks that that is a jurisdictional question. That's why those questions can be forfeited. Judge Quattlebaum, I think you put your finger right on it when you looked at the analogy between 1331 federal question jurisdiction and 1334 bankruptcy jurisdiction. They're actually phrased in exactly the same way. The courts shall have jurisdiction over cases involving laws of the United States in one, and cases involving Chapter 11 in the other. If you actually take their argument seriously, every lawsuit in federal court under federal question jurisdiction 1331 that seeks to enforce a federal statute raises the non-waivable jurisdictional question whether that federal statute, for example, violates the Commerce Clause. That cannot possibly be right. That means every single case in a federal statute, you would be obligated to undertake the inquiry whether or not that federal statute was
So
constitutional.
they cite in their reply brief a case called Reed. I don't mean to, there's a bunch of cases cited. It's the case that deals, I don't know, this will be familiar with the criminal prosecution of the wife of a person in the military. And the Supreme Court said something to the fact that, the wife has Fifth Amendment rights, has Sixth Amendment rights, and they use the term jurisdiction there. And it, from the cases I read, it was, maybe similar to the argument here. They're saying that, look, this case is going into a bankruptcy court. It's implicating our Fifth and Seventh Amendment rights.
Sure.
I don't know if you have a position on that case.
Well, Your Honor, I think I have a couple of responses.
Go
I
ahead.
think the first one is that, as the Supreme Court has made very clear over recent years, the term jurisdiction in the past has gotten thrown around in a very loose way.
Right.
And here we're talking about a very specific type of jurisdiction where the court has said that Congress has to speak quite clearly in order to make
You
something
think that
jurisdictional.
the bankruptcy judge erred in ruling on subject matter jurisdiction?
Yes, Your Honor, I do. And here, I don't think there's any way you can look at the bankruptcy clause and see it as any different than any other enumerated power like the Commerce Clause that somehow imbues it with some jurisdictional concept. Now, to the extent I recall that case, and I don't have it at the front of my mind, but I think that it really did involve, when you were prosecuting a non-military member in a military court. And you could see how that might start getting into what you would traditionally think of as a jurisdictional question. But that's very different when you're coming in with an argument that says the application of a federal statute to this case exceeds one of Congress's enumerated powers. When that happens, nobody has ever thought that that was a jurisdictional question. So I completely agree with what your questions are suggesting, which is that this is not a jurisdictional dispute. There are other ways that they can try to raise it. Maybe down the road, I think that they're gonna fail on the merits and probably for other reasons too. But they certainly can't raise it in the context of this interlocutory appeal.
Maybe this isn't a jurisdictional question I'm about to ask, but I'd like your view on it. I mean, the Seventh Amendment right to a jury trial is important, and the bankruptcy code seems to speak to that in the terms of personal injury cases. Is there anything you can tell us about the ability of claimants to opt out?
Yes.
It may be totally irrelevant, but the overall context of making sure the Constitution, is complied with is still important.
Yes, the way that these plans always work is at the end of the day, any particular claimant has a right to say, I don't like what's being offered to me by the plan, and I'm going to go to court and exercise my right to a jury trial. Every court that has addressed this concept in the context of bankruptcy proceedings has said that that process satisfies both the statutory requirement and the Seventh Amendment constitutional requirement. Frankly, if there's anything here that I think has been abrogating their interest in getting a jury trial, it's the tort system. It was when they were languishing for 10, 15 years or more without a trial. This really is the only way we have to try to solve this problem.
So if the process that's proposed in the plan is extremely aggressive and results in some cram down of the value of these claims, is the remedy for that to oppose confirmation and to not vote for the 524G? Is that the way that issue like that would get flushed out?
That is certainly the first step in the process, Your Honor. Look, we have every incentive to try to get not just 75% of them to agree, but to a much higher percentage than that. Because we don't hit that 75% threshold, we're thrown right back into the tort system and all of the uncertainty that we were dealing with back then. Our strong goal is to put forth a very strong plan that's not just going to get 75% support from their clients, but a much higher percentage from that. And again, I think we're going to be able to get there. We've got 40 years of litigation history in this field. We have a pretty good sense for what a fair price for a claim is. We're going to be putting those fair prices out there, but they're going to have a chance to say whether they agree with us or not. And if they don't agree with us, they're not going to vote for the plan. We have to hit that 75% threshold if any of this is going to work, which is why we have been working night and day to settle this case. We've already put $1 billion on the table. That was our opening bid in the qualified trust. And we've been working night and day to try to resolve this issue. To be honest, I don't fully understand why my friends have been fighting so hard to prevent us from paying their clients.
So, again, all this is interesting, but I'm not really sure it goes to what I understand the opposing party has said, which is this bankruptcy clause constitutional defect. And as I understood answers to the questions, opposing counsel indicated, I guess from 1789, when the Judiciary Act was first adopted, that this has just never come up in 230 years because there's never been a debtor like this.
Well, Your Honor,
response to that?
Sure, respectfully, I disagree. If you look at the modern day corporate reorganization under Chapter 11, it doesn't typically involve an unwillingness to pay or an inability to pay. The core of their argument really, although they don't say this, is that there's an insolvency requirement that's baked into the bankruptcy clause. They keep using the word inability to pay. If you look up the definition of insolvency, either at the time of the founding or today, it is quite literally the inability to pay. So effectively what they're saying is that the bankruptcy clause has an insolvency requirement, but they can't admit that, because if they admitted that, that would render virtually the entire modern code unconstitutional. Well, if it doesn't have an insolvency requirement for which there might be at least some modicum of historical support, where do you get to this nebulous notion of financial trouble? There's simply no support for it at all. And if you were to follow their approach, you really are calling into question virtually the entire modern bankruptcy code. At the time of the founding, it did not apply to corporations. That didn't occur until the late 1800s. It was extremely controversial. At the time of the founding, there was no concept of a voluntary petition. Everything was involuntary. There certainly was no concept of a corporate restructuring such as is commonplace today. So ask yourself, what is in common between a modern-day voluntary corporate restructuring of a non-solvent debtor, happens today, and an involuntary petition against a merchant who had absconded without paying his debts back in 1789? The one thing that those two things have in common is what the Supreme Court has said is the core of the bankruptcy power. This is the Siegel decision 2022. The subject of bankruptcies is incapable of final definition and includes nothing less than the subject of relations between a debtor and his creditors. So I think that's the full answer to their constitutional question, both on the merits and from a jurisdictional perspective. There's simply no basis to say that arguing that Congress has exceeded its enumerated powers either on its face or as applied in a particular case is a jurisdictional question. It's a merits question. Even if you get to the merits, it fails on the merits. So one sort of final point I want to make on this is even if you had bought into this general notion that there ought to be some notion of financial trouble or financial distress, whether baked into the Constitution or into the code, even though the code says absolutely nothing about it, I actually think that 524G is best understood.
Well, it does if it's a Chapter 9 municipal bankruptcy, and I think that's the only place in the bankruptcy code that shows up.
I 100% agree, Your Honor. But if you look at 524G itself, it really is, in a sense, an asbestos-specific financial trouble requirement. It only applies if a debtor is faced with future asbestos liabilities, if the timing, number, scope, size of those liabilities is uncertain, if that uncertainty threatens the ability to treat both the future unknown claimants, they haven't even manifested the disease yet, with the current known ones fairly and equitably, if 3/4 of them support it, and if a bankruptcy court and a district court approve it. And that's why in this case, the bankruptcy court explicitly found that we met the quote-unquote financial distress requirements that were baked into 524G itself. And again, it goes back to what the whole point of 524G is. It's to eliminate that uncertainty given the 50 to 60-year latency period of asbestos diseases. We can eliminate the uncertainty that both we and they face over the next 50 to 60 years by coming to an agreement today to eliminate that uncertainty, but only again if they support it, if we have a future claimants representative that supports the unknown future claimants so their interests are protected, and if you have a bankruptcy court and a district court that then approves of that plan. So I think that there's no way that there's jurisdiction here, but even if you somehow were able to twist yourself into knots to figure out how a straightforward argument that a law is unconstitutional is a jurisdictional question, even if you could get through that basic position, there's no way that this claim survives on the merits either. I am happy to answer other questions you have, Your Honor. May I take 1 second before I cede the rest of my time?
May.
Thank you, Your Honors.
Thank you very much, sir. Mr. Frederick?
Judge Quattlebaum, if I could start with your question, the Reed case holds clearly that Congress cannot use Article I powers to expand Article III beyond constitutional limits. That was the whole point of saying there was no jurisdiction over the wife of the service member. Judge Agee, to your questions about solvency, we are not attacking or trying to change insolvency requirements that are statutorily set forth. What we're saying is that this case can be resolved from the very simple principle that their own concession and the finding by the bankruptcy court of their ability to meet all their obligations now and in the foreseeable future means that they are not a proper debtor within the bankruptcy clause's meaning. It has a subject matter jurisdiction component because at the founding, there was both a substantive and a procedural quality to the meaning of a bankruptcy. Substantively, it was applying to non-paying debtors. Procedurally, it was transforming what were state bankruptcy practices into a uniform practice under federal court jurisdiction. But that federal court jurisdiction cannot undercut or undermine the limitations that are imposed by Article III itself. That's why Congress couldn't change the diversity requirement after the Supreme Court held that the Constitution required complete diversity. That's why the court has had many cases construing standing, construing the words, what is a case or controversy, a very vague and general term, to limit the scope of Article III jurisdiction. All we are saying is that in light of the other structural protections in the Constitution for due process, for jury trial rights, it is improper to construe bankruptcy clause in a manner that would delimit what a bankruptcy is because of the profound effects that that would have on.
You mentioned Reed, and I asked your colleague about that, and you had a response, and I spent some time with that, and the word jurisdiction is used in that case a decent amount, but it seems like it's really referring to the military court's jurisdiction. And it's not talking about federal subject matter jurisdiction like we're having here. It seems to me, if I read that, tell me if I'm wrong. You've spent more time with it than me, but I read that case more along the lines that prosecuting a military person's spouse in military courts would be unconstitutional than it would be than dealing with a question of whether the military code is a federal question.
That's because ordinarily military courts martials are not in Article III courts.
Well,
They're
I understand,
actually,
but yes, you're right, but that also may be a reason why that shows your argument is that maybe this process is unconstitutional, not that that we don't have subject matter jurisdiction to deal with it.
you have subject matter jurisdiction to decide your jurisdiction.
Well, I understand
Of course.
that, yeah.
The point, though, is that just like standing, or if we were to come in here with a non-diverse set of parties, you would say, on the facts as applied, you do not meet the constitutional limitations of an Article III court, right? And so here what we're saying is that as applied in this circumstance, because of the concessions they have made, they have taken themselves out of the jurisdiction of an Article III court, which they have to have in order to get a 524G injunction. Because the channeling injunction purpose of 524G is to tell all state courts everywhere, if you get a claim, you have to shunt it off to the bankruptcy court process or to the trust process. That is a fundamental transformation of our federalist system. And that is what.
Interesting to, I shouldn't do this, but I can't resist.
But to get at what was the interpretation in 1789, you're relying on what are really Second Amendment cases. Somebody cites Heller in here.
Well, the Rahimi principle of constitutional interpretation is supported by the three prongs of our argument. Textualism. At the time of the founding, bankruptcy had a meaning. It was non-paying debtor. History. Throughout the course of history.
Also allowed debtors prisons at that time, and during the convention, there was apparently the only discussion on the bankruptcy clause was whether or not the death penalty would be allowed.
Those were for unwilling debtors, the process that would be triggered by creditors for putting non-paying but able debtors through their paces. There are two forms of debtors that we're talking about under the bankruptcy clause, those that are unwilling and those that are unable. This case only concerns the ability to pay because Bestwall has said throughout it is willing to do so. And the question is whether you're going to allow this case to set a precedent for wealthy corporations across the country to invoke bankruptcy to figure out how to get venue in the Western District of North Carolina, which has...
That's not right. The response to that is Congress did that, not us. So, I mean, you have an argument and it's fair, but to try to suggest, we interpret the law, we're not creating something. Congress either, as Judge Agee mentioned earlier, it would be, this has been in the news for a while. It would be easily with a stroke of a pen to put up, the sort of requirement in the code that you're saying exists.
But you have the power to determine what the power of the federal judiciary is under Article 3.
sure.
And you have the power to say, as applied, interpreting the statute as Bestwall and the bankruptcy court has sought to do is unconstitutional because it expands the subject matter jurisdiction of federal courts beyond proper limits. You have that power, Judge Quattlebaum, and that's what we're suggesting that you do here. We're not trying to say there are no proper non-paying debtors who can't invoke bankruptcy, but where they concede and where it's been found, they have the full ability to pay now and into the conceivable future. That surely expands and delimits Article 3 jurisdiction. And we know from standing and other principles that having limited jurisdiction is a core element of the constitutional bargain that was made at the founding. Unless the court has anything further, I would just close by saying this bankruptcy has already been going for 8 years. It's likely to go for another 5. So the idea that somehow the state tort system is inferior to this process on the basis of speed is wrong. Creditors are supposed to be driving Chapter 11 in order to maximize the return for creditors from a limited res. In an in rem action where you have basically an unlimited res, you are transforming the bargaining leverage in a Chapter 11 from the creditors who ordinarily have that leverage to the debtor, which is willing to pay, but only on its own terms. And that's why Bestwall has already rejected 2 plans that have been proposed by the creditors. This process is not going to end, and I do not mean to suggest there is something that you shouldn't do, but you have to police what is going on with these bankruptcies, with corporations that have every ability and willingness to pay, but are seeking to change the bankruptcy system in a manner that harms those that the corporation has hindered.
You've already got your plan confirmation argument down.
But Your Honor, why would we have to go for 5 more years where it's not?
But you've raised subject matter jurisdiction here.
Yes.
All of this could go to the merits of that. It's not subject matter jurisdiction.
It is subject matter jurisdiction if it falls outside the limitations imposed by the word bankruptcy in Article 1. That position, Your Honor, is that we're going to allow a special process to delimit Article 3 jurisdiction for bankruptcy. And the answer to that is going to be every wealthy corporation that wants to get out of its leases, its office leases, its payment contracts, is going to invoke a bankruptcy, get it into the Western District of North Carolina, and then come up to this circuit where you're going to say, wait to confirmation.
524Gs.
Your Honor, the 524G problem that he is seeking to evade is the fact that after they have rejected 2 proposed plans of confirmation, it's very clear to the claimants they are only willing to accept a plan that would be on their own terms. And that means that it will not get the requisite number of votes to qualify as 524G. And in the meantime, Bestwall gets a payment holiday. While they have not paid any claimants over the last 8 years, Georgia Pacific has upstreamed to Koch Industries $7.5 billion of dividends, which probably would have taken care of all the claimants. It probably would have taken care of the trust. But that's not what they're seeking to do. They're seeking to force a situation where the estates of deceased asbestos victims have to come supplicating to Bestwall in order to get something. And that's not right. And there's no basis for there to be a conclusion that Congress or the founders intended the bankruptcy process to cause that to be within an Article III court.
Thank you very much, Mr. Frederick.
Thank you.
We appreciate the arguments of counsel. We'll take the matter under advisement. We're going to come down and greet counsel and then proceed to the next case.
Kind of cleaning house now.
Yeah, lost our fans. Pardon? Oh, I didn't show that. In our third case, Jane Roe versus the Marshall University Board of Governors. Ms. Meth?
Good morning, Your Honors. I'm Madeline Meth, and I direct the appellate clinic at Boston University School of Law. And it's my pleasure to introduce my colleague and student attorney, Gregory Bowe, who will be handling this morning's argument on behalf of appellant Jane Roe.
Good to have you with us, and we appreciate Mr. Bowe. Yes, come forward.
Your Honors, and may it please the court. Greg Bowe for appellant Jane Roe. I'd like to request 4 minutes for rebuttal. When Jane Roe reported to Marshall University that she had been sexually assaulted by her ex-boyfriend, John Doe, Marshall made her situation worse. Instead of protecting Roe and her access to education, Marshall investigated and punished her. I'll begin by addressing the causation element of Roe's retaliation claim. Marshall says that its hands were tied and that it had to investigate and punish Roe because of her underage drinking at a September 3rd party. But that can't be true because both Roe and Doe told Marshall of other students that were drinking underage at that same party, and Marshall did not investigate or punish them.
I thought they both refused to give names of anybody else who was drinking.
Your Honor, that is what Marshall says, but Roe actually specifically named a Marshall student who was at that party in her first meeting with student conduct. Doe also offered to provide.
I thought she named an individual, but I'm not aware of anything in the record that indicates that that person was a Marshall student.
Well, we know that that student
What
was.
we're talking about is what's in the record. So does the record show that?
Well, at JA 518, we can see that in her deposition, Roe explained that that other student, Abby, was indeed a Marshall student.
Right, but that's different than whether during the investigation, she told the Marshall University folks that's what this person was, because this only came after the fact.
Well, that's true, Your Honor, but I think it's a reasonable inference for this court to draw that
Roe either explained that fact to the student conduct office or that the student conduct office understood there to be more Marshall students at that party, considering how both Roe and Doe were Marshall students at that party. The only material difference, Your Honors, between Roe and those other students that were at that party is that Roe had engaged in protected activity by reporting sexual harassment, and those other students did not. All Marshall has done in trying to rebut that evidence is create a genuine dispute of material fact.
Yeah, this interesting though. I mean, the kind of implication of that is that if someone makes a complaint like we have here, and information through the course of that report, does involve conduct that is serious and contrary to policies, what's the school supposed to do? I mean, you could have a policy that says if you bring such a claim, as a matter of policy, we're not going to prosecute you at all or do any investigation or anything. I mean, that could be something the school does, but it doesn't. I wonder if that's necessarily improper not to have that. I mean, why can't a school discover facts of misconduct by a person reporting an event and take action on those? And why isn't that what we have here? It may seem less serious because there's probably a good bit of underage drinking going on at most colleges, but still it's a violation, and we could replace it with underage drinking with something more serious. And your argument seems like it would keep the college from taking that, from prosecuting or taking action on that type of a event.
Right. So our
How's
argument.
underage drinking defined here?
Excuse me, Your Honor?
Underage drinking, how's that defined? 18, 21?
I think it would be
What's the underage?
21, Your
What's
Honor.
the age? Under 21
right.
And that's by state statute.
or by West Virginia law?
Yes, Your Honor. So our argument is
Be a lot of
really.
students at Marshall University, that large percentage of them be under 21, wouldn't they?
That's right, Your Honor. And our argument is specific to underage drinking in that we know from research that underage drinking is often a factor in assaults on college campuses. And that's why it's specifically underage drinking and not other kinds of potentially more harmful student conduct violations that should really not be allowed to be prosecuted by these schools when it comes to light in the course of a student conduct.
So that's the rule you want, that if the misconduct that's investigated is, we have a special rule for underage drinking? Is that what you're advocating for?
That is a rule that we advocate for, but this court doesn't need to go that far in order to remand Roe's retaliation claim. All that Roe needs to show is that Marshall took materially adverse action against her because of her protected activity. And the evidence that Roe points to goes beyond just this comparator evidence. She also points to evidence showing what Marshall's real motive was in punishing Roe and evidence of procedural irregularities in its investigation into her, which shows that Marshall's purported legitimate reasons for punishing her are pretextual. So the record shows that Marshall's real motivation for punishing Roe was to chill Title IX reporting and thereby protect its reputation. At the time Roe reported her harassment, Marshall had ample reason to shield its Title IX office from further scrutiny. It had been sued 3 times in recent years over deficiencies in its Title IX office, and it was aware that a USA Today article criticizing its Title IX office was going to be published soon. So on this evidence, a reasonable jury could.
So how does investigating Jane Roe help Marshall in that regard?
So, Your Honor, a reasonable jury could conclude that in order to chill Title IX reporting, Marshall funneled Roe's case out of its Title IX office, investigated and punished Roe to send Roe and reasonable students in her shoes a message that reporting sexual harassment to Marshall was a bad idea and it'll have bad consequences for those who do it, and that Marshall won't support you.
Sounds like you got a theory, but not much evidence.
Well, Your Honor, I think the fact that Marshall treated Roe differently from those similarly situated students at the party is evidence. I think that Marshall had.
Right, but the record, as you've recited it, only had one other person that was identified. And there seems to be some confusion as to whether or not that was a student, but there's no evidence that that person was underage, is there?
I think it's a reasonable inference to draw, Your Honor, that at least some of the 5 Marshall students that we now know who were at that party were underage and drinking. Doe explained that there were 10 people at the party and that all of them were drinking. As I believe Judge King mentioned earlier, most students at the campus are probably under the age of 21.
A lot of them are, I'm sure. A sizable number, I suspect, are.
That's right, that's right. And that's why I think
Is there any evidence of whether these were freshmen or seniors or grad students or anything like that?
Well, based on the ages of Roe and Doe, I think it's a reasonable inference to draw that some of those 5 other students who were there were underage. I'd like to turn now to Roe's deliberate indifference claim. In this case, Marshall responded in a clearly unreasonable manner to student-on-student sexual harassment that it had substantial control over. Marshall's clearly unreasonable conduct included its punishment of Roe, its failure to investigate the incidents of harassment that occurred prior to September 3rd that Roe reported to Marshall's Student Conduct Office, Marshall's failure to offer Roe any meaningful supportive measures, as well as its decision to funnel Roe's case out of its Title IX office. And the circumstances also show that Marshall had substantial control over the context of Roe's harassment. Davis and Hurley make clear that when a school has the remedial authority to address harassment, it has substantial control over the context of that harassment.
Is that right? I mean, I thought that your statement would be true if you said over the conduct of the assaulter, the disciplinary action would be enough to do that. But are you saying that disciplinary action, the ability to discipline a student, equals the ability to have control over the context?
Well, Your Honor, we're not saying that disciplinary authority equals control over context. Control over context.
Okay, go ahead.
Is a different question than control over harasser. But we are saying that disciplinary authority is relevant to control over context. And that's because the level of disciplinary authority that a school has over a context affects how much influence the school has over student conduct in that context.
Assume though, if you could, I mean, we have a specific element the case law says about control over the assaulter, and discipline, authority goes to that. It sounds like you're saying when you go to the separate issue of control over context, that issue is relevant to that question too. Okay. Besides that, what's your evidence in the record that there was control over this context?
So, Your Honor, in addition to disciplinary authority, we also look to some of the factors that this court looked to in Feminist Majority Foundation versus Hurley, such as where the harassment occurred, which was in the immediate vicinity of campus, who the harassment specifically targeted, which here was Roe, a Marshall student. And we also have to consider that the harassment wasn't limited to the September 3rd assault, right? Roe reported incidents that occurred prior to September 3rd, and then the harassment also spilled over onto Marshall's campus in the form of the hostile environment that Marshall allowed to exist there. And Marshall certainly had the authority and the ability to take steps to remedy the hostile environment. For example, it could have given Roe supportive measures. For instance, it could have provided her with mental health supports, given that she had developed a fear of returning to campus and indeed almost completely avoided campus for over a year after her assault. It could have identified ways for her to make up work, and it could have helped her communicate the circumstances of her student conduct violation to her nursing supervisors so she could have avoided the humiliation she felt when she told them about it. Now, Marshall maintains that it provides such measures to all victims of sexual assault, but Marshall made the clearly unreasonable decision here to not offer any of those measures to Roe. And it made that decision knowing just how severe the September 3rd assault was, and knowing that Doe had abused her in the past. The interim no contact order between Roe and Doe that Marshall put in place doesn't mean that Marshall's response was at all reasonable. On the contrary, the no contact order was a half-hearted remedial measure which is insufficient to relieve Marshall of liability. And that's specifically because Marshall never informed Roe that the no contact order was still effective after her punishment. We actually don't really know if the order remained effective after her punishment. And because it never told her that, as I said before, Roe was terrified to return to campus out of fear of seeing Doe. And she avoided campus almost completely for over a year after her assault. One other way that Marshall's conduct was clearly unreasonable here was that it decided to transfer Roe's case out of its Title IX office and dismiss it as a Title IX matter without having enough information to make a good faith determination that the harassment had occurred outside of a school program or activity. For instance, Marshall didn't check to see whether a school-sponsored event had occurred at the location where Roe was assaulted.
Is the standard for this issue deliberate indifference? Is whether it was
Yes, the standard is deliberate
indifference.
indifference.
So it's not enough that to sustain the claim that they could have kept this as a Title IX claim. They have to have done so to transfer in a deliberately indifferent manner, correct?
That's correct. And this court has described that standard in Feminist Majority Foundation as the school needs to take steps that were reasonably calculated to end the harassment or make the victim less vulnerable to
Doesn't
further
say clearly
harassment.
reasonable. I mean, I don't mean to quibble over words, but reasonably calculated is just negligence. Deliberate indifference isn't negligence. I think there was some qualifying on reasonable, or else we might as well not use deliberate indifference when we're talking about a reasonable standard, right?
That's right, Your Honor. So that's a quote directly from Feminist Majority that I brought up, but yes, this court and the Supreme Court has also used the words clearly unreasonable. If there are no more questions at this time, then I'll look forward to answering more in rebuttal.
Thank you.
Thank you very much, sir. Mr. Oxley?
May it please the court. My name is Perry Oxley, and along with my co-counsel, Zach Ramey, with the law firm of Oxley Rich Sammons, I represent Marshall University Board of Governors.
Good to have you with us, Mr. Oxley. Good to be.
Thank you. In this particular instance, we have a case where Marshall University clearly did not have substantial control over the context of the events that occurred. Specifically, this occurred right after a football game. There was a party at a residence not owned, leased, or controlled by Marshall University, at which the party took place. Marshall did not have a student, faculty member, group organization ask for request. Marshall University did not provide any of the funds for this party. This was simply a couple of guys who decided to have some people over to have a good time. The bottom line is that Marshall University had no mechanism at all in any way, shape, or form to know what was happening that night. In essence, it was completely separate and outside their control. Not only did they not have substantial control, they had no control. They had no idea what was going on. So if we look at cases, Your Honors, that go through what it is that makes this up, if we look at, the Hurley case was referenced earlier. The Hurley case involves a scenario where you're talking about a university network being involved in that case. You're talking about a scenario where there's on-campus harassment. That's clearly official decision-making and control over that situation involved. We look at Brown. In the Brown versus Arizona case, the football team had control over where Brown lived in a separate apartment. They controlled exactly, they could move him back on campus if he didn't follow rules, and the coaches were monitoring what he did. When we look at Simpson versus University of Colorado Boulder, in that particular case, they were looking at, they had official football recruiting exercises where recruits were, quote unquote, showed a good time by going out with females to, I guess in my understanding, inappropriate sexual conduct in order to recruit them. The bottom line is that in each of these cases, in every case that I've looked at in the course of reviewing this, substantial control requires some official authority or act. In this instance, this is the classic example of a scenario in which a university doesn't have substantial control.
How far off campus was it?
It was within a few blocks. It was in a block or so of campus. But it was a private, not Marshall-owned, not Marshall-leased, not Marshall-controlled. For instance, they had absolutely no control over this residence whatsoever, any more than they would over any other private residence owned by an individual.
Was it a home or or an apartment building or what?
It was an apartment, is my understanding, Your Honor. And basically, it was owned by an individual who lived there and had invited Doe over to the party. And so, Your Honor, if you look at the case law, there's absolutely no evidence of substantial control. And I just want to point out that the appellant makes a continued claim that somehow the control over the harasser means that the university had control over the context. They are separate and distinct elements, as this court pointed out earlier. You can't merge the two and confuse them together such that they become one.
So
They're separate.
Is control over the context, is that an essential element of the claim? In other words, let's assume your colleague talked about did not investigate prior misconduct, and you may have a position on that just as a matter of that particular issue. But my first question is whether control of the context, let's assume hypothetically we conclude there is none. Is that the end of the case?
Yes, it is, Your Honor.
So that you,
Based on Davis, Your Honor, it is the end of the case.
so unless if there are other misconduct about transferring and things like that, control of the context is an essential element?
Correct, Your Honor. And the Davis case clearly states, in order to make a claim under Title IX, it sets forth the 4 factors. The second factor is control over both the harasser and the context. So I don't think that the appellant can meet the elements set forth in Davis if they don't prove that there was not only control over the harasser, but control over the context. And this all relates back to the Gerber case, where where Title IX sort of had its origins. And the bottom line is in that situation, we're talking about a school situation. And the court talks about the fact that the entity has control over the students while they're in the class, while they're in the school facility. And so basically, Davis says, can you do harasser on harasser? Can we go beyond, not harass, I'm sorry, student on student? Can we go student on student harassment, extend it there? And the extension includes this requirement that they have control over that
So let me, so
context.
let's assume you have a serial assaulter who's a student. They've done it 2 or 3 times, school's just being lax, and then they assault someone else in a place like this, off campus, no control over it, no school-sponsored activity, things like that. But the school has knowledge of an assaulter's prior misconduct. Are you saying that that's an invalid claim under Title IX?
No, what I'm saying is that there's a certain class of cases called heightened scrutiny cases, where an individual has, there's an LSU case that involves this exact issue, where there's a series of cases prior to that the university has investigated and dealt with, and then let go or not enforced, and then this person has a subsequent event. So there's a heightened scrutiny that person might be a problem on
So
campus.
under that, so.
But
in
Doe
that
has none of
case-
that, Your Honor.
Well-
Never been in trouble before in his life, never after either.
Let me ask my question.
Okay.
So I mean, but structurally, if there was evidence that Doe had been guilty of misconduct and it was known, you wouldn't have to show control of the context in that case. You would be more focused on the individual?
My argument, Your Honor, would be that that case law is suggestive of the fact that the control of the context is the university's control of that individual and those prior incidences and not taking action against him, and then him going out subsequently and doing it. I think that controls the context. I mean,
Yeah, which kind of does get back in a little bit, in all candor, to the control of the student is relevant. Those things kind of merge a little bit. I understand your position, we don't have that. I'm just trying to make sure I understand how we evaluate the claims.
Yeah, I think this is the clearest case of not having control of the context that I've ever seen in my career. I mean, it's very clear, based on the facts of this case, that Marshall University had no knowledge whatsoever of this. This student had a clean record, had never been in trouble in the past, and was simply a one-off incident that occurred in this particular instance for which they had became aware of at that particular point in time. And so, and I think the district court addressed that issue in their brief by saying that, hey, this was cited to us by the appellant and dealt with it in that regard. Moving on, Your Honor, to the deliberate indifference, I don't believe we need to go any further than substantial control. I believe we can put the case to rest there. They don't have it, they can't prove it, the evidence is clear, there's absolutely nothing to support that. When we come to deliberate indifference, I want to make, I want to first say that we went through this evaluation committee. It's very clear that Marshall's policy is if they don't have substantial control of the context of the incidents, policy GA1, then the complaint, whether the report or the incident gets referred to student conduct. And it says, the policy for Marshall University says it shall be dismissed, and it doesn't prevent them from moving forward under some other mechanism. In this case, that mechanism was student conduct. And so they referred this incident to student conduct. It came to them from the police. Now, it's very important to understand that Roe never made a complaint to Marshall University. In fact, after the investigation, before the investigation, and after the investigation, she never came to Marshall University and said, I've got a problem here. I want to file a Title IX complaint. I want to file a complaint. After the incident and the investigation and the assigned sanction, she never came back and said, I got a problem or something else is going on. This is, in fact, the entire time she went to Marshall University, she never made any sort of complaint about Doe. This came to their awareness because the Huntington Police Department investigated and made a report to Marshall University. Marshall University took that report and evaluated it to their evaluation committee. After reviewing the report, they made the determination this falls within student conduct. And immediately, when this got to student conduct, they issued a no contact order. I think it's very important to understand what Roe's testimony is with respect to the no contact order. First off, Roe received this with this email right here. She got with the no contact order, came with this email. This email says, the order is in immediate effect until further notice. I read it straight from you. It's JA 919. Roe testified that Doe has not attempted to contact her since September the 7th, 2002, and that she has not tried to contact him. Roe testified that the last time that she would have communicated with Doe would have been the night of the incident. Roe testified that no one at Marshall University ever told her the no contact order had been lifted. Roe testified that she received the no contact order before she ever said anything to Marshall University about the incident on September the 3rd, 2022. In other words, they put this no contact order in place for her benefit without her even requesting it. Far afield from deliberate indifference. Roe testified that the no contact order issued by Marshall University benefited her, and Roe never filed a complaint with Marshall University of any kind whatsoever against Doe, ever. So, in these other cases, for instance, in the Hurley case or other cases where we have continued ongoing issues arising, where the harasser is continuing to glare or whatnot at the individual or something to that nature. Nothing occurred, no other incidents occurred until this day. She has not had any contact with Doe. So the no contact order was effective. They've had no contact, and this issue was resolved as a result of that. Now, it goes into an investigatory mode. The investigator is a lady by the name of Michaela Arthur. She interviewed each individual on multiple occasions over the course of several weeks. She drew the conclusion that Doe was responsible for this incident, and she found him liable for physical and emotional abuse, relationship violence, and underage drinking, and she sanctioned him by making him go through an alcohol course and doing community service, 20 hours of community service. And then she enforced and put him on probation, and she enforced that sanction against him, and he served that sanction, okay? I mean, candidly, in instances where someone is investigated, found responsible, and sanctioned, it's hard to make the argument that the university was deliberately indifferent, particularly when they put in no contact orders, which are effective by admission of the appellant. Now, they also, during the course of that investigation, found that she is responsible for underage drinking, and they sanctioned her for underage drinking. Now, it's also important to note that she was advised that she had the right to an advisor. She had a right to.
What about the other student?
Which other, Doe?
Who were there that you didn't sanction?
Well, we asked, the investigator asked the questions of the investigator, or asked of both Doe and Roe, what are the names of these people? And they would not give them. They would not cooperate. They were trying to protect their friends. The only thing I believe they knew was the name Emma accompanied her. I'm not aware of the record. I don't want to speak out of turn, but they didn't know how old Emma was, and they didn't know anything else about that. And so they didn't feel like they had enough information to move forward at that particular point in time.
So, why wouldn't they? I mean, there's a party, there's an event that the police have been called, there's students there. A person says she's assaulted. She is not wanting to reveal names. I understand you don't have names other than one, but you got one. Did the school say, hey, let me at least ask Emma? I got one name.
I don't know that they knew any more than Emma. My understanding is I don't know that Roe wanted to provide any additional information concerning the people that were there.
But, yeah, I mean, you know the students. I mean, there's a lot you have to rely on the district court side. You talked all about the punishment of Doe, and that's all fair, but, if you line it up with Rose, it's the exact same thing other than like 10 hours different. So, putting them together, it looks maybe questionable. Maybe not. We're not school conduct,
Sure.
second guessers or micromanagers, but, just looking at that seems pretty odd, given the context. And if the underage drinking is important enough that she gets this, effectively the same penalty as an assaulter, and one might question why you don't go to at least check out the one name you know of.
My understanding, Your Honor, is from the record, more than 80 people were investigated for underage drinking during this time period and found to have violated that rule and sanctioned for it in the same capacity as Doe and Roe in this particular instance. I don't know that I can, as it pertains to the punishment, as this court just pointed out, and, the Davis case is pretty clear that we have to kind of let the school administrators handle that stuff. I would also point out, as the district court pointed out in his opinion, Doe was ongoing criminal allegations and dealing with the prosecutor's office on his conduct, and I think the university was probably aware of that also. Again, I hearken back to the scope of what the student conduct is attempting to do, and I think when they're not provided or stonewalled on information concerning how to move forward, it creates difficulties. I mean, I'm sure that if they had unlimited resources, they might be able to go out and follow people around and whatnot. You know what I'm trying, but they have to rely upon people to cooperate with the investigation, answer questions. So with respect, moving to retaliation, Your Honor, there's no evidence at all of retaliation in this case.
Well, they sanctioned her for underage drinking.
Yeah, but
That's what he said. Oh, that was his evidence.
Yes, Your Honor, and I understand
You just said they didn't have any evidence.
Your Honor, I don't think they have any evidence. I really don't, because we initiated the investigation. We initiated the no contact order. We're the ones that called her in to see us. She was surprised that when she testified, she was surprised to have received the no contact order and received that we were even involved in investigating the matter. We called her in, we interviewed her, obtained information from her, sanctioned him for his conduct. So why, I mean, it's nonsensical in my opinion, and the evidence doesn't suggest in any way that we would then come in and say, we're going to retaliate against you for cooperating with an investigation that we started and then used to punish Doe. And so, I mean, I think
why not? There is. Do you deny there's protected activity under the retaliation claim?
What I would say, Your Honor, is that she just cooperated with an investigation and just coming in and telling her story. I don't know that that fits this. She didn't file a complaint under Title IX. She didn't file a complaint with student conduct per se.
So you don't think answering questions from a school that is, investigating a matter is protected activity?
Well, super assuming that that's the case, Your Honor. I mean, I understand, just assuming that that is the case. In this particular instance, we didn't retaliate, and there's no evidence, to Judge King's question earlier, there's no causal evidence that we took any action with her because she told us about Doe's conduct. In fact, the evidence suggests that based on her testimony about Doe's conduct, we punished and sanctioned Doe, a sanction he served. And so my point is that, Marshall, if you take deliberate indifference, and, well,
We're not dealing with that here, are we? Because,
correct, it's retaliation, but I think all of this goes away because there's not substantial control over the incident, but.
Well, but that doesn't have anything to do with retaliation.
Yes, so what I'm saying, though, is that in this context, there's no evidence, there's no direct evidence that Marshall took an action. There's no testimony in this case by anyone of any kind that Marshall decided we're going to impose an underage drinking requirement or sanction against you because you came in and told us about Doe's conduct. In fact, all the evidence suggests that in obtaining that information, we then punished Doe by finding him responsible and issuing a sanction. Your Honors, I would ask that you affirm the decision, unless there's any more questions.
Thank you, Mr. Oxley. Mr. Bowe?
Your Honors, I'd like to start by addressing Roe's protected activity. My colleague says that Roe never reported sexual harassment or her sexual assault to Marshall, but that's just not true. First of all, Roe did report directly to Marshall's Student Conduct Office that Doe had harassed her multiple times prior to September 3rd. That's a direct report. And then also the Supreme Court in Crawford.
When did she do that?
During her first meeting with Student Conduct, she told them that Doe had shoved her and held her wrists in the past,
Right.
that he had verbally and emotionally abused her, and then Student Conduct also at that point had the police report from Huntington
That's
Police.
probably sufficient, but there were no reports before the incident, and she did not make a separate report after the incident, other than in responding to questions. Is that what the record shows? Is that accurate?
I think I have two responses, Your Honor. So first of all, the Supreme Court has explained in its decision Crawford that people can oppose discrimination just as
Right, but I
surely.
mean, from a factual standpoint, and from what I recited, is that factually accurate? And then you can tell me whatever you want about the implications of that.
That's right. Marshall heard of the September 3rd assault from Huntington Police, and Marshall heard about the pre-September 3rd harassment from Roe herself directly. In Crawford, the Supreme Court explained that people can oppose discrimination just as surely by responding to questions from other people as by provoking the discussion themselves. It wouldn't make sense for schools to be able to preempt retaliation claims just by starting an investigation as soon as it heard of harassment without regard to the school's retaliatory motive. And then second of all, Roe may have actually filed a formal Title IX complaint or reported more or pursued further sanctions against Doe if she hadn't been punished. She actually explained that she would have spoken out publicly and filed a formal complaint if if Marshall had not punished her. I'd also like to use some time to address the argument that we're somehow blurring the lines between control over harasser and control over context. We're not trying to do that. The two elements are distinct. One important thing to recognize, though, is that they are trying to answer the same basic question, which is, under the circumstances of this case, did the school have the remedial authority to address the harassment? Now, the control over harasser question specifically asks about the school's ability to circumscribe the conduct of the harasser, but for control over context, the Supreme Court chose a much broader word, context. So for control over context, we instead ask about the ability of the school to address the harassment considering all the circumstances. And that's why this court in Feminist Majority looked at not just location, but also what the school could have done to address the harassment, including through issuing disciplinary sanctions to the harassers and who the harassment targeted. If I may finish my response, that's also why the court in Brown v. Arizona looked expressly to disciplinary authority to determine that the school had substantial control over the context.
Thank you very much, Mr. Bowe. And we appreciate the work of the students at Boston College?
University.
Boston University. Make sure I get it right.
Yeah.
That's right. And you had some assistance, I think, from Mr. Donovan, who I know from way, way back. And we appreciate counsel's arguments, and we'll take the case under advisement and adjourn court till tomorrow. Thank you, Madam Clerk.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.